All right, so I'm going to do a quick little estate planning presentation. Quickly who I am. I am a working mom. I have 2 little girls. I also have a business, right? So I have to think about how do I protect my business. And in addition to being an attorney, I had a mother who needed a Medicaid trust. So I've done it from all the levels, right? So I'm having to, protect people as well as in my family as well as my clients. So I come from a personal protection aspect. So what is estate planning? Estate planning means making a plan in advance that establishes who will receive your assets and who will carry out your wishes if you become incapacitated or after you die. It also includes who can make financial and medical decisions when you become incapacitated. So a lot of people think, oh, I have a will, I'm all good. Well, no, that doesn't take care of incapacity, and that can be a big deal for people. So when you're, thinking about buying a home, or if you're a homeowner recently, questions to prepare is, what's my long-term plans, right? I have this house, am I gonna sell it right away as an investment? Do I wanna keep it for my family as intergenerational wealth? What happens when you die or become incapacitated? And who would make decisions in that kind of crazy, unfortunate scenario? As Janet was kind of saying, if you haven't, slow down. If you haven't done an estate plan, there's a plan in place. New York has this plan. Every state has one. It's called intestate laws. Hi.
Hi. Better late than never.
So I'm Leslie. I'm the estate planning attorney. We just started. We're going to get into the fun stuff, probate. I get to talk about when people die. So I try to make it lively, Leslie.
We do that.
So, especially with co-ops, right? We were kind of, Janet was talking about those. First, I like to tell people what probate is, right? It's the process to transfer your assets when you die, with or without a will, okay? So if you have one, it's going to court. If you don't have one, going to court. What most people don't know is that probate court, the surrogate's court, is set up not for the families to inherit. Anybody know what probate court was set up for? Creditors. Creditors. So we live in a market economy, right? We want credit. Everybody wants to lend. But how do they collect the money when someone dies? Back in England, there was a church, when they had the separation of church and state, around that time, before that time, you could go after someone's family for debts. They had servitude. And so, correct me if I'm wrong, maybe you know the history better. Your children were responsible for the debts of the parents, and generations that eventually stopped, right? So now you can't go after the children for the parents' debts, but you can go through surrogates court, probate court. So the first people who get to collect are the creditors, okay? Most people think, oh, it'll be my family. Family comes last, okay? So then, of course, is how long does probate take? So most states, it's quick. New York is not, okay? Florida, not. California, not. If you have less than $50,000, it's called a small estate. Those are quick, okay? So if you want to keep it really low, you'll be fast in probate court. A couple weeks.
We should spend now.
Yeah.
Okay.
Enjoy it quick, guys.
Yeah. Enjoy while you're alive.
$50,001 full probate. Okay, you're in a different department in the court. That can take months on average, depending on the times. Right now, the Bronx is the worst. Don't die in the Bronx.
Oh, boy.
I can't tell you the whys. I can just tell you that maybe there's
Jenna,
just
don't die in the Bronx. You're closer than I am.
It backed up, too many people, less clerks. I don't know. Queens is actually really fast. It's happened, couple months. Brooklyn was the worst during COVID. That's a long story, but they're much faster now. Nassau. So the point is, we want to try to stay out of court.
What about Suffolk?
Suffolk, like 9 months to a year. You can't get anyone on the phone. We had to send someone down to Riverhead just to get an answer. Yeah. Oh, wow. And then there's the cost of probate. Okay, so you don't have to have an attorney, but most people do because you're stressed, you're grieving, and you're going down to the courthouse and filling out paperwork and having to do these affidavits. So first thing to know is that the surrogates court is the most expensive court in the state of New York. If your total value is $500,000 or more, which most homeowners are, you're paying $1,300 just to file the will, just to start a case, okay? Then there's attorney's fees, right? So most attorneys charge an hourly rate, $450 to $800 an hour. They're gonna take a retainer, $5,000, $10,000. Some people, well, okay, I'm waiting for my inheritance. I don't have any money. You know, how do I hire an attorney? I don't have any money. Well, the attorneys work out a contingency fee. Okay, I'll do all the work and I'll take 10% or 5%. Let's say 5% of $1 million. That's $50,000 to the attorney, not to your family. So it gets expensive. Most people see, well, I have a will. Am I done? I'm good, right? No, Janet, where there's a will, there's probate. So it has to go through the court. It has to be validated. You cannot take a will to the bank and say, give me my money. They have no way to tell if it's real, if it's fake. The problem, one of the biggest problems with wills is even if you were to say, I'm going to disinherit my son who I haven't talked to in 20 years, he gets an opportunity to come to court and dispute that will.
But you did.
No, right. Well, he's going to say, oh, she didn't mean to disinherit me. We made up. Whatever it is, she can't just argue about that, right? She's not here. So with a will, everybody who's supposed to receive has to get notified and given an opportunity, due process, to come to court and contest it. This is why some of these cases take so long. Where is that son that we haven't talked to in 20 years? We see this a lot with, second marriages, right? They had a kid maybe in another country, never raised the kid, now they're married, new family, bam, dies. That kid got to be found in the other country and given an opportunity to come to court. Meanwhile, no assets can be transferred. All the accounts are frozen. Nobody has authority. If you have a rental property, you can't collect the rents. There's nobody with authority to collect the rents. 6 months later, you try to collect the rent. Oh, I was just appointed by the court. Can I have my money? Somehow the tenants never have the money. Eventually, of course, someone will get appointed. The money can be distributed, but now you're reimbursing legal fees. You're trying to make up for the arrears that the tenant didn't pay. We want to try to keep you out of court. And don't forget the creditors get paid first, right? So, once you file, it's public notice. And so certain credit cards, for example, they have a registry. So every time someone's filed in the surrogate's court, ding, they get a notice. And then, boom, they send the notices, and now they're trying to collect the money. And so everyone's on notice. The only good thing about surrogate's court and probate is that creditors only have 7 months. So, bing, it filed, 7 months go by. If they don't file the proper notice, their debt is cut off. That's the only good thing. Okay, so then 9 months later, oh wait, we need to collect rent. Sorry, your 7 months is over, statute of limitations. All right, so here's the big question you should all be asking: how do I avoid probate?
Spend everything.
You don't have to spend everything, but you can create a trust. Okay, the magic word here. So a trust is a legal document, right? We take our assets out of our name and we put it into the trust. If you have a deed, you're literally taking your name off the deed and putting the name of the trust as the owner of the house. Bank accounts, it's no longer the Leslie Sultan checking account, it's the Leslie Sultan Trust checking account.
What about business accounts?
Business accounts, no. Business accounts stay in the business, but the behind the scenes, the ownership changes from you to the trust. And then you're the owner of the trust. So it's the same thing, but immediately upon your passing, whoever you appoint gets to take over the business. Very good question, very savvy strategy, and it works. The beauty of the trust is that once you pass away, as I said, the successor trustee automatically gets to take over. No court. It's an automatic transfer. They have full authority. I like to use the analogy of a purse. So I say right now everything's in your pockets. When you die, they can't just go through your pockets and get your stuff. They got to go through court to get permission. But we're going to take everything during your lifetime out of your pockets and put it into the bag. The bag is the trust. All right? And then I'm the trustee during my lifetime. So I can still take everything out. I could sell my house. I could buy a new house. Everything's in the bag. When I die, I name Janet as the trustee. She just takes the bag. And now she's in charge.
No court.
No court. Thank you. So that's how the trust works.
How long does it take things to move into a trust?
That's a good question. I mean, ideally you're gonna, it's 2 steps. First is creating the trust, and then is funding the trust. So, you know, you go create your trust, the next day you go to the bank, they create the bank account, move the money. The deed we always do at signing. So if you have a house, we sign the trust, you're signing the deed. If you have a business, we're signing assignments to the trust.
What happens to the mortgage?
Mortgage, good question. Under the Garden St. Germain Act that was formed in the 1980s, a lender cannot recall the loan if you transfer without their consent to a trust.
Nice.
So they have protection as long as you are living in the house. You know, there's some rules, but essentially, yep, you can transfer to your trust. Never even have to let the mortgage lender know. If they find out, you just say Garden St. Germain Act. You'll remember that, right? and they'll be fine. We never really see it anyways, but okay. So again, what is a trust? It's a legal written document. The creator is the grantor, also the trustee, and also the beneficiary. So it's all of these things for the benefit of your estate. And we can say how everything's distributed in there and who can manage it with no judicial intervention. Now, a lot of people say, do I get asset protection, right? So nobody can sue me if I put it into the trust. Good question. So here's the thing, a revocable living trust is, you know, a powerful tool used to avoid probate and protect the privacy of the trust. It's not in the courts, nobody knows about it, for the beneficiaries, and sometimes it can minimize estate tax. But if I'm in control of the bag, a judge can say, well, then you can write a check. So you do not get asset protection with a revocable trust. Only if a third person, if Janet is controlling my trust while I'm alive, then if someone sues me, they can't come after it because I don't own it. I have no control over the bag. She does. And they can't go after her because she didn't do anything wrong. She's just managing my trust. We see this most often with Medicaid trusts. So these are very popular in New York because although our probate system is terrible, our Medicaid system is good. So you can get you can qualify for Medicaid even though you have millions of dollars, as long as you move it into a trust with a third person managing it. Okay, because then you don't own anything, and now you're qualified for Medicaid.
How old do you have to be for that?
All right, so you have to be 65 years of age, blind or disabled. You have to be a resident of New York State and be unable to perform at least 2 activities of daily living. So those are the lists there. Once you create the trust, we have to move everything because you can only have $32,000 in your name. So anything above that goes into a trust savings account, right? We create a savings account, we move the money. The house goes into the trust. And yeah. All right, so I just used this, I already gave you the person analogy, but this is just another way the red wagon. She's pulling the red wagon, all the stuff's in there. Right, so funding, if you don't fund your trust, it goes through probate. So you are gonna have to go to court even if you have a trust, if you didn't move the stuff into it. So we wanna make sure to do that. Yes?
The person holding the purse now, do they control your money?
So technically they're writing all the checks, but you always have the power to remove them. And the language says everything has to be for your benefit. So if I appoint Janet, now all of a sudden Janet's on some crazy safari trips and she's spent a lot of money that I didn't realize she had, I could say, you know, I don't trust Janet. I'm going to remove her and appoint someone else.
Does Janet need to know what you have?
Yes, she would have access to everything. Yeah. So clearly you want to pick someone you trust, that you can oversee. You know, it's not like, hey, who wants to be my trustee today? So yeah, so good question. And you know, unfortunately for some people, this is just not an option, right? They don't have someone that they can appoint and qualify for Medicaid, even though they really need it. In some cases, there's corporate trustees, right? Like the Morgan Stanley, they'll do that, but of course they take fees. So you kind of really want to speak to an estate planning attorney about what's the best way to do all this. Did you have a question? Yeah.
Just a question. Let's say I trust her, she trusts me. She appoints me, I appoint her. Do we still qualify for, let's say, Medicaid?
Yeah, because the relationship's not going to matter.
No, but now
Now if you're married, that's a different
no,
story.
we're not married. Never gonna get married. No.
Ever again.
No. The point more, let's say if somebody becomes a trustee, right? Now I have the bag.
Yeah.
So that comes with responsibility, but it's not my money, right? So
Correct.
it doesn't count as mine.
Correct. So it's kind of like being the
Let's just do
CEO,
that.
like the CEO of a company, right? You can't sue the CEO and go after all the company's assets.
Mhm.
Yeah, they're in a fiduciary capacity, but not owner. Hi, how are you? All right. So last little bit, just because I like to, be very thorough and comprehensive. We talked about estate planning, but really important is something called a power of attorney document. It's not a superhero, but it is kind of. It's a very powerful tool for when you become incapacitated, unable to sign. So my mom, for example, she had dementia. I would ask her, what day is it? And she'd be like, 19. She just couldn't write a check anymore. So she had power of attorney, luckily. She'd done it when she had capacity, and so now I was able to take over. It can also be used if, you're out of the country and you get stranded. We saw this during COVID. Now someone else can go in, get to the checks, and pay the mortgage. Obviously physical incapacity, you're stuck in a hospital for a while, someone's got to go collect the rent from the tenants. With power of attorney, they could do that. And of course, mentally incapacitated. If you don't have a power of attorney and you lose capacity, you have to have what's called a guardianship proceeding in the Supreme Court. These are awful, okay? They're expensive, right? There's attorneys for the family member that wants to be the guardian. Then the court appoints attorney for the alleged incapacitated person. Then there's a court evaluator. They're going to the house. They're going through all the medical records, the bank statements. Very invasive. Not what anybody wants when all you have to do is fill out one form and you're done. But you don't want to do power of attorney because literally that person can go and take all the money out of your account. So it has to be someone you trust, obviously. So we definitely, you want to think about full comprehensive estate planning. Any questions I'll take now. Are we doing questions at the end, I think? Yeah.
We kind of
did them on through. And that's my contact information. Thank you guys for your time on a Saturday. Yes.
So, one more question. So, say for example, you have a will, but then you've gone through the process and you want to change it. Yeah.
Good question.
So,
so a will, we don't recommend like amending a will. We recommend just doing a new one.
Okay.
Yeah. And then a trust, if you've done a trust, can always be amended. So you just kind of add a sheet to it saying, I'm hereby changing paragraph 12, so that instead of Janet being my trustee, Michael's going to be my trustee.
Because, there was a celebrity who passed away. I think she had a will, but she wrote a note or something, and they found it under the couch.
Aretha Franklin?
Yeah.
Yes.
And that had precedence because, it was something that was written later on.
So unfortunately, Aretha Franklin, when she died, they couldn't find a will. So they appointed her niece as the administrator, which is another term for who's going to administer the estate when there's no will. And then the administrator was able to get into the house and go through the house and found a notebook with wishes under the couch and another one in a bedroom in a locked drawer. So then it became a debate. Which one is her wishes and why isn't this a formally done document? Now, my theory is a lot of people don't trust attorneys, so she just never. So she,
money in cash. She didn't want checks.
Yeah. So unfortunately, she never went to an attorney and did it the proper way. So this was battled through the courts for years because one document said I would leave everything to this son, and the other document said I leave everything to that son. So eventually, the court determined that this one was her closest intentions and gave that son everything. And that was for years, and then the taxes weren't paid, so at the end of the day, the estate was reduced.
That's like friends.
Yes.
That's the point. Do not have a will, have a trust.
Yes, thank you.
Everybody cancel your wills.
Just get a trust. I just got one.
That was a big mistake. You should have come here earlier.
So now that you've protected your assets,
get rid of it.
So, do you do trust?
I do trust, yeah. You're going to want to learn how to level up your homeownership game and grow your assets for legacy, planning. So we have Michael here.
Thank you, Leslie.
So,
Motivational one.